Saturday morning. And before you scroll, before you check any other outlet, before any anchor tells you what to think about what happened Thursday, I need you to understand one thing. 47 seconds of audio, that is all it took. 47 seconds. Recorded at a private estate in New Jersey on a warm July evening in 2021, stored on an unencrypted personal device, transferred twice before federal authorities ever touched it, played aloud inside a sealed federal courtroom at 2:14 p.m. Eastern on Thursday afternoon. The room held 31 people, no cameras, no press pool, doors locked. And according to sealed hearing transcripts that leaked to 3 separate news organizations by Friday night, when the recording ended, nobody in that room said a single word for several long seconds. The silence told you everything. You saw the headlines. Every outlet covered the tape. Not one of them told you about the GPS records. Not one of them explained what the judge's sequencing of orders actually signals. And not one of them connected the 4-year pattern that made Thursday's 47 seconds feel less like a surprise and more like the final act of something that was always going to end this way. In the next few minutes, you'll see exactly how this recording was obtained, why the chain of custody is now the center of the entire legal fight, why a second layer of evidence may be more dangerous than the tape itself, and why the date to watch right now is June 17th. I read the full federal filing, all 127 pages, 3 times before writing this. Here is what the documents actually say. The story doesn't start Thursday. It starts 14 months ago, when the National Archives sent a formal certified written request for the return of 31 specific classified items, each one identified by its individual document control number, each one formally logged as missing from federal archives. That request wasn't a suggestion, it was a legal demand. And 8 of those 31 items carried a secondary priority flag, meaning federal archivists had identified them as requiring immediate recovery due to their classification level and subject matter. The response came 8 weeks later. A written statement from legal representatives asserting that all requested materials had been returned and fully accounted for. They had not been returned. 6 weeks after that false written assurance, a federal grand jury subpoena went out, broader this time, more specific, targeting not just the documents themselves, but communications records, calendar logs, facility access records, and physical movement documentation spanning an 18-month window. Now, here is what was already quietly in motion 7 weeks before the meeting that produced the tape. Classified files had been formally flagged missing. A written notice demanding their return had been delivered and signed for. Legal teams had been quietly notified. And at a private estate in Bedminster, New Jersey, a property that does not appear on any official schedule for that period, not flagged, not disclosed to federal record keepers, someone was preparing for a meeting that was never supposed to be documented. Then came the night the boxes started moving. Between August and November of 2021, 14 storage containers were relocated between 2 separate facilities. Those movements were logged not by federal investigators, not by any government agency, but by a commercial facility management system with GPS timestamps embedded in its routine operational record. Nobody deleted those records. Nobody overwrote them. They sat in a commercial database for 4 years, quietly accumulating timestamps, waiting for a federal subpoena that eventually found them. The meeting at Bedminster happened first. The boxes moved after. What happened inside that meeting is what the tape captured and what no one in that room believed would ever surface in a federal courtroom. They were wrong. If you're just finding this channel, hit subscribe right now. This story moves fast, and I break every document drop the moment it lands. Don't miss the next one. And comment June 17 below. That's the date that changes everything. July 2021. A private room at a New Jersey estate. A meeting not logged on any official schedule. Somewhere in that room, a device was recording. The individual holding that device identified in court documents only as a cooperating individual. Their identity deliberately withheld from all public portions of the filing was trusted enough to be in that room. That single fact is worth sitting with for a moment. This wasn't a government surveillance operation. This wasn't a court-ordered wiretap. This was someone who had been welcomed into that private meeting and chose to document what was said. What was said ended up on page 31 of Thursday's federal filing in the District of Columbia. According to the official court transcript included in that filing, the recording captures a voice positively identified by 3 separate forensic audio analysts across 2 independent laboratories discussing a specific military planning document. That document is described in the filing in language that leaves no interpretive room, not declassified, not authorized for this setting, and not something that should have been removed from federal custody. That is not my characterization. That is the government's filing, verbatim. In plain English, the speaker acknowledged in their own words, on a tape now entered into federal evidence, that a classified military document sitting in that private room had 0 legal business being there. Now turn to page 58 of the same filing, completely different section. The government describes a second voice captured on the recording, an unidentified individual asking a direct question about the document's current classification status. The response, captured word for word in the court record, the document was still classified. Present tense. After leaving federal office. No declassification order on file. No legal authorization for removal. 7 weeks before this conversation, the National Archives had formally requested that document's return. Put those 2 moments on a timeline. A document formally requested by federal archivist. A meeting held at a private property with no official record. A conversation confirming the document was still classified and still present. And a recording of all of it stored on a personal device, unencrypted, unprotected, that would change hands twice before federal prosecutors ever took custody of it. The recording was made without the full knowledge of at least one other person present in that room. The conversation captured on tape directly contradicts sworn written statements submitted by legal representatives to federal investigators approximately 6 months later. All of it documented, all of it in the public record. And in late 2024, under sworn deposition, someone looked federal investigators in the eye and stated for the record, there is no recording. There was never a recording. I was never in that room. The recording exists. The person was in that room. The full deposition transcript from that proceeding is now entered as Exhibit B in Thursday's federal filing. Pattern spanning 4 years. Deny access, claim compliance, deny knowledge, issue a statement, repeat every single time, got away with it, until Thursday afternoon, 2:14 p.m. Eastern. Stay with me, because the detail buried on page 89 is what makes this story even more dangerous. What nobody's covering. Buried on page 89 of Thursday's filing, inside Exhibit F, there's a chain of custody notation that should be getting far more attention than the tape itself. The original recording was not stored on a government device, not encrypted, not secured through any official protocol. It was stored on a personal device and then transferred twice before federal prosecutors ever took custody of it. Read that again slowly. A recording of a conversation about a classified military document stored on an unencrypted personal device transferred twice before federal custody. That single fact changes the shape of this story significantly. And it is the foundation of the defense team's entire counterattack. Their position, this is a politically motivated evidentiary ambush. A recording that surfaced years after the relevant events, delivered through a chain of custody that 2 independent digital forensics experts have already flagged in writing as potentially compromised. The recording was obtained from a third party who had a documented financial incentive to cooperate with federal prosecutors. The metadata embedded in the audio file shows 2 separate edit timestamps made before the file was delivered to the government. And the individual who physically transferred the recording had previously attempted to sell access to private meetings to a media organization, a negotiation that reached $340,000 before falling through. A fact the prosecution did not disclose anywhere in the original filing. That is their case. It deserves to be stated clearly. Lead defense attorney, a former assistant U.S. attorney with 19 years of federal criminal practice, put it directly. Authentication is everything in a case like this. A tape with a broken chain of custody proves nothing in a federal court of law. The court-appointed special master herself, a former federal district court judge with 31 years of evidentiary experience, acknowledged in a written submission. The authentication questions raised here are not trivial, and they warrant a complete evidentiary hearing before any probative weight can be assigned to this material. That is genuinely not nothing. But here is what happened the moment the playback ended in that courtroom. Emergency motions filed by defense counsel that same night. A request for a gag order denied by Friday morning. A judicial order for in-camera review of 3 additional audio files flagged by prosecutors, all due for submission by next Wednesday. Within 36 hours of that tape being played aloud, the legal landscape of this case shifted visibly. And Judge Simmons, as of Friday evening, has not dismissed this recording. She has, in fact, ordered it preserved, reviewed, and authenticated on an expedited schedule that gives neither side much time. That is just the first document. If you're still watching, hit that like button right now and tell me in the comments, what do you think happens by June 10th? And subscribe, because what I show you next is the layer of evidence that may end up mattering more than the tape itself. 31 people in a sealed courtroom in the District of Columbia, no cameras, no press, doors locked. Federal Judge Loretta Simmons, presiding over an obstruction-related evidentiary hearing, looked at the room and said 7 words before pressing play. The recording speaks for itself. 47 seconds. According to the sealed hearing transcript leaked to 3 separate news organizations by Friday evening, independently corroborated across all 3 versions, the room went completely silent during the playback and stayed that way for several seconds after the audio ended. Defense counsel moved for an emergency recess the moment the recording concluded. Judge Simmons denied it on the spot. No hesitation, no deliberation. What followed moved at a speed that told you exactly how prepared each side was for this moment. Within 45 minutes of playback concluding, lead prosecutors filed a supplemental exhibit package pre-staged, ready to deploy the instant the tape was authenticated in open court. Judge Simmons then issued a 72-hour window for full forensic authentication responses from both sides. No extensions available, no exceptions, 72 hours. That clock started ticking at 2:14 p.m. Thursday, but here is what every outlet missed while they were writing their tape stories. Thursday afternoon, after the audio playback concluded and while defense counsel was still processing the denial of their emergency recess motion, Judge Simmons issued a completely separate sealed order. It had nothing to do with the recording. It was about the boxes. Specifically, GPS movement records pulled from a commercial facility management system showing 14 storage containers relocated between 2 separate facilities between August and November of 2021. Records that were never deleted, never overwritten, never flagged for removal. Those GPS timestamps were cross-referenced against sworn deposition testimony from 6 former staff members. The documented discrepancy runs across 23 specific dates, 23 instances where what the GPS records show directly contradicts what was said under oath. Judge Simmons responded to that discrepancy by scheduling a follow-up hearing for June 17th. Not reactive, calculated. A judge who orders a secret tape played aloud in open evidentiary proceedings rather than admitting it quietly as a written exhibit is making a deliberate choice. She is creating an oral record, one that exists in a form that survives every appellate layer above her. She is building a case that cannot be unwound on appeal. She did it in a single afternoon. The legal landscape of this case shifted visibly within 36 hours of that tape being played. But that's just one layer of evidence. The second layer is what actually keeps the defense up at night. Here is what gets lost in the tape coverage. The tape has a chain of custody problem. The defense has real arguments. But now consider what happens when you place those arguments alongside the GPS record. 14 storage containers, 23 specific dates between August and November of 2021. Commercial GPS timestamps embedded in routine facility management data, not created by prosecutors, not created by investigators, not created by anyone with a stake in this case, created automatically by a commercial logistics system that had no reason to falsify anything. Those records were cross-referenced against sworn deposition testimony from 6 former staff members. The discrepancy covers 23 dates. And here is the detail that has received almost zero coverage. The sealed exhibit list references 31 total dates of GPS documented movement. Only 23 have appeared in public filings. 8 dates remain entirely unaccounted for, and neither the prosecution nor the defense has addressed that numerical gap in any public submission. 8 dates, 14 boxes, and a judge who has already admitted the GPS records as active evidentiary material without a single defense objection holding. Former chief of the DOJ's Public Integrity Section, now a law professor at Georgetown University Law Center, explained the evidentiary logic. The chain of custody issue is real. The defense is correct to press it hard, but it is survivable for prosecutors if the tape's content receives independent corroboration from a separate evidentiary source. And the GPS movement logs appear to provide exactly that kind of structural corroboration. The tape doesn't need to stand alone. It only needs one additional evidentiary pillar. Those GPS records may be that pillar. Former federal prosecutor, 16 years inside the DOJ's National Security Division. When a judge orders a recording played aloud in open evidentiary proceedings, rather than quietly admitting it as a written exhibit, that's a deliberate signal. She wants it on the record in a form that survives every appellate layer above her. And here is what cuts through the partisan noise entirely. Even a former senior litigation counsel who worked on defense strategy in a related earlier proceeding in this same case has publicly conceded if the GPS timestamps align chronologically with what the audio captures, the authentication challenge becomes extremely difficult to sustain before any serious appellate bench. When people on opposite sides of an active legal battle independently reach the same technical conclusion, you pay attention to that. Professional consensus across the spectrum. The authentication challenge is substantively real, but unlikely to be fatal to the prosecution's case if the GPS records hold under scrutiny. Why does this reach you personally? Real talk. If you have ever signed a federal document, submitted a compliance certification, filed a tax return, or put anything in writing to a government agency, pay attention to what this case is establishing right now. The current filing proposes up to $2.3 million in civil forfeiture tied specifically to document handling violations entirely separate from any criminal exposure. The broader precedent, when sworn written statements contradict recorded evidence, prosecutors are now moving aggressively and federal judges are letting them. Here is what that means practically. Next time you are in any legal proceeding, civil, administrative, or criminal, and the other party claims a specific conversation never happened, courts now look for audio, for GPS metadata, for device transfer logs, for facility access records. If you are in a business dispute, a landlord-tenant disagreement, a contract negotiation, where someone later denies a meeting took place, the evidentiary framework being built in this courtroom right now gives attorneys representing ordinary people tools that simply did not exist in the same legal form before last Thursday. And consider the uncomfortable part nobody wants to say out loud. The recording was made by someone trusted enough to be in that private room. That person then transferred it twice before handing it to federal prosecutors. If you have ever assumed that a private professional meeting was a secure environment, that assumption was tested in open federal court this week, and the recording was admitted. Practical steps that informed people are taking right now. Reviewing any sworn written statements made in proximity to private meetings between 2020 and 2023 for potential contradictions. Consulting legal counsel about document preservation obligations if they ever received, handled, or were adjacent to government materials. And asking their attorney one specific question. Does any recorded conversation I am aware of contradict anything I have submitted in writing to a federal or state authority? Who is directly affected right now? 14 individuals named as unindicted co-conspirators in the underlying obstruction case have had their legal teams filing emergency motions within 48 hours of the playback. They are not waiting for a verdict. They are moving now. Knowledge helps. That is the whole point. Friday afternoon, hours after news of Thursday's audio playback leaked to the first news outlet, a statement arrived through a spokesperson. It called Thursday's federal court proceeding a staged political performance, using a doctored recording manufactured for maximum media damage ahead of the midterm cycle. The full quote, This tape proves nothing except that our opponents will manufacture and weaponize anything to interfere with the democratic will of 77 million Americans. The statement was published, then deleted. 41 minutes later, it reappeared in an edited version. The edit specifically removed a line that referred to the presiding judge by name. Read that again. Someone published a statement attacking an active federal court proceeding. Then someone made the decision to delete it, modify it, and repost it with the judge's name surgically removed. In 41 minutes. Within hours, at least 4 prominent federal legal commentators flagged publicly that characterizing an active Article III federal court proceeding as a staged political performance is language that can itself attract judicial scrutiny and potentially a sanctions review. The prosecution issued an 8-word public response. 8 words. The court record will speak for itself entirely. Then came Friday night's final move. Defense counsel filed an emergency motion requesting a full stay of all evidentiary proceedings pending completion of the authentication review. That motion is sitting on Judge Simmons' desk as of this morning unanswered. Judge Simmons has denied every stay motion and every preservation request filed by defense counsel through Friday night. 0 exceptions granted. This is not winding down. It is accelerating. What is still genuinely unclear: who made the original recording and under what legal authority the filing identifies the recorder only as a cooperating individual and deliberately withholds their identity from all public portions. The GPS movement data covers 23 specific dates, but the sealed exhibit list references 31 total dates. 8 dates remain entirely unaccounted for in any public filing, and neither side has addressed that numerical gap publicly. The clock is running on all of it simultaneously. Here is exactly where things stand as of Saturday, the 7th of June, 2026. A 4/7-second audio recording made at a private estate in the summer of 2021, stored on an unencrypted personal device, transferred twice before federal custody was played aloud in a sealed federal courtroom on Thursday afternoon. Confirmed by transcript leaks across 3 independent news organizations, the GPS movement exhibit covering 14 storage containers across 23 specific dates is now formally admitted and active in the evidentiary record. A judge who chose to play that recording out loud rather than admit it quietly as a paper exhibit has made a deliberate, calculated decision about the kind of record she is building for what comes next. Surface read, this is a tape story. But the GPS movement records may be the more consequential evidentiary layer in the long run. 2 pillars of evidence. Either one alone is survivable for the defense. Together, the experts on both sides are telling you the same thing. The dates that matter: June 10th, defense forensic authentication report due to the court. 4 days from now, no extensions. June 17th, full evidentiary authentication hearing before Judge Simmons, open to limited press access. That is the day the admissibility fight either holds together or falls apart. Week of June 23rd, a separate parallel grand jury proceeding has a scheduled witness appearance, identity not yet public. 3 more unknowns still outstanding: the identity of the individual who made the original recording, the content of 3 additional audio files Judge Simmons ordered reviewed by this coming Wednesday, and those 8 GPS dates that remain entirely unaccounted for in any public filing. I will be watching the June 17th authentication hearing closely. When the next documents drop, I will break them down line by line. Story is not over, still developing. So there you have it, the full breakdown of how a 4/7-second secret recording shifted an entire federal obstruction case in a single afternoon, why the GPS movement records may ultimately matter more than the tape itself, and exactly why June 17th is the date that changes everything. This is the moment federal courts are testing what happens when 4 years of sworn denials collide with 47 seconds of audio and commercial GPS data that nobody thought to delete. If this video gave you the full picture, not just the headline like it, drop your biggest question in the comments and subscribe to American Flashpoint today for every document drop, every filing, every development as it happens. You won't get this level of breakdown anywhere else. I'll see you when the next one lands. Talk soon.